Your Excellencies, honorable judges, distinguished guests, dear colleagues. The distinguished speakers this morning highlight the importance of having a robust judicial architecture for safeguarding human rights in criminal proceedings for atrocity crimes. And as the Undersecretary General and Special Advisor on the Prevention of Genocide, Ms. Ndurito, also emphasized in her keynote address this morning, building a solid foundation for prevention of genocide is absolutely essential. Indeed, trials before international criminal tribunals are often against high-profile accused, involve charges of mass atrocities that have caused immense pain and suffering to hundreds or thousands of victims and survivors and their families. Such trials deservedly capture the attention of entire communities. Their significance transcends national boundaries, and their legacy becomes a tenet of the world's conscience. At the same time, it is often emphasized that the success of a criminal tribunal is not measured only by the numbers of acquittals or convictions. It is measured by its ability to deliver justice, by ensuring the fundamental rights of the accused to a fair trial and the victim's access to justice. These are integral to a well-functioning judicial system, being at a domestic or international level. And this is the focus also of our first panel today, fair trial rights and harmonizing standards of justice. I would like to briefly introduce our distinguished panelists. Judge Salome Bosse brings a wealth of judicial experience. She has been a judge of the International Criminal Court since 2018 and previously served as a judge of the International Residual Mechanism for Criminal Tribunals, the International Criminal Tribunal for Rwanda, the African Court of Human and People's Rights, the East African Court of Justice, as well as the Court of Appeal and the High Court of Uganda. Welcome, Judge Bosse. Judge Margaret de Guzman, I have the privilege of knowing personally Judge de Guzman, as she is a judge at the International Residual Mechanism for Criminal Tribunals. She is also a professor of law at Temple University, Beasley School of Law. Judge de Guzman served as a legal advisor to the Senegal delegation at the Rome Conference, where the founding treaty of the International Criminal Court was adopted. Judge de Guzman has published extensively on the formation and application of international criminal justice norms and is on the editorial board of the African Journal of International Criminal Justice. A very warm welcome to you, Judge de Guzman. We are joined also today by Ms. Tembile Seguete, who is the Senior Legal Officer and Officer in Charge of the Office of the Prosecutor of the International Residual Mechanism for Criminal Tribunals here at the Arusha branch. Ms. Seguete previously served as the Legal Advisor and Appeals Counsel at the International Criminal Tribunal for Rwanda, as well as a Principal Legal Officer at the African Court of Human and People's Rights. It is an immense pleasure to have you on this panel, Ms. Seguete. As you will hear today, our panelists will elaborate on key aspects of fair trial rights and will address the harmonization or the lack thereof of standards of justice. I hope you enjoy the panel discussion and invite you to take advantage of this unique opportunity and ask our panelists any questions that you may have. I turn now to you first, Judge Bosse. Drawing on your vast experience with international criminal tribunals and having been also a judge at the African Court of Human and People's Rights, do these judicial institutions, in your view, have a harmonized approach to fair trial rights?
Thank you. I would say yes. And this is, you've touched on a robust architecture of the basic documents of these courts, which all incorporate the provisions of the International the ICCPR, and they, in one way or another, constitute part of their respective statutes. So in interpreting the fair trial rights of an accused person, and there is a nuance with the African court because it's not an international criminal court, but I'll explain that shortly. They have all looked at the ICCPR, they've looked at the jurisprudence of the International Human Rights Court, they've looked at the jurisprudence of each other, and I think they understand that they have to set standards, international standards, the gold standards to be followed by domestic jurisdictions. And they have taken the same approach to fair trial rights, right from arrest up to release, early or not. So I looked at the jurisprudence of these courts, and it's all the same. It points to the same things. The accused must not be arrested and left languishing somewhere for days on end without being taken to court. He is entitled to counsel, he is entitled to defense, equality of arms, and so on. Now, the African court is slightly different because it has various jurisdictions, but it also has this jurisdiction conferred on it by the African Court Protocol. And states which have made a declaration accepting that individuals can access the court can challenge proceedings before these domestic jurisdictions, especially criminal ones. And the court examines whether these criminal trials really adhere to international standards. And the African court has made the same pronouncements as the international criminal courts. The right to counsel, the right to speedy trial, right to defense, and so on and so forth. So I'm happy to see that these international courts, criminal courts, and the African court have the same approach. They look at each other's work, and they look at the work of the human rights courts, which are specialized in this area, and are guided by each other. So that has led to harmony and standardization, and avoided the fracture of the international criminal law or international law.
Thank you, Judge Bossa. I think you mentioned earlier that you would like to elaborate more on some provisions that an International Criminal Court has applied. Would you like to do it now, or shall we move to Judge de Guzman?
Well, the statutes of all these international criminal courts have sections or articles which confer rights on accused persons during trial. And they are the same ones because they all incorporated from the International Covenant on Civil and Political Rights. They were all incorporated from there. So they are the same. And therefore, it's not surprising that in interpreting these provisions, the courts have taken the same approach to their interpretation. So they've interpreted them more broadly to go beyond the minimum guarantees for fair trial. They touch on the fairness of the bench. They touch on the expeditiousness of the proceedings. They touch on freedom from bias from the people who are trying the accused, and so on. So, and these courts, especially the international criminal courts, try the same crimes. So they have to differ to each other's interpretation. Of course, there will be circumstances when there will be slight differences in the rules. For example, the ad hoc tribunals had the same rules and they had the same appeal chamber. So their jurisprudence was more or less the same. The International Criminal Court is slightly different because it is said to have a hybrid system. A unique one, it also has special procedures for complementarity, which the other tribunals didn't have. And it's also a court of last resort as compared to these ones which had primacy. So those differences manifest in the decisions that have been made, but on core crimes, core rights, and the things that really matter in international criminal law and international human rights law, they've been the same.
Thank you very much, Judge Bosse. We'll turn now to another important aspect of international trials for atrocity crimes, and that is the victim's access to justice. We have witnessed, as it was mentioned this morning also in the keynote speech, the evolution of the role that victims play in criminal proceedings, from participating solely as witnesses before the ad hoc tribunals to participating in their own capacity as victims and claiming reparations for harm they might have suffered before the International Criminal Court. And we will discuss this extremely important subject with Judge de Guzman. Judge de Guzman, how have international criminal courts balanced the rights of defendants with the rights of victims to participate in the criminal proceedings?
Thanks, Amelia. And let me start by thanking the organizers, especially President Gatti, for including me on this very important panel and on this very important occasion. And especially thank you to you, Amelia. Since you didn't get a proper introduction, I also just want to say that Amelia, as I'm sure most of you know, is someone who's been working in international criminal law for decades and has a wealth of experience on these issues. So I hope that you will also chime in substantively on the discussions that we're going to have. So when I was asked to talk about this topic of the harmonization of fair trial rights, one of the things that occurred to me immediately is that an area where there's a need for more harmonization is this question of the need to protect defendants' fair trial rights while also ensuring victims' rights to participation. And it's the reason that it's an area in need of further harmonization and I think discussion is that it's a relatively new aspect of the global justice architecture, let's say, coming sort of mostly to the fore with the ICC. So I'm going to frame the issue a little bit, but I warned some of my friends in the audience that I would be coming to you as well in the hopes that you would chime in on some of these issues, because many of you have been at the forefront of developing the norms that seek to include victims in a meaningful way while also protecting defendants' rights. And so some of my defense counsel friends, Kate Gibson and Ian Edwards, have agreed to chime in with their experiences. And we also, of course, have some ICC judges here. Judge Guyu, who is just leaving his post as a judge at the Kosovo Specialist Chambers and is moving into the ICC, so has had experience in both capacities, and of course, Judge Bosse. So I just want to say I'm going to introduce the topic, but there are many others in the audience with more experience that I hope will chime in and give your views when we get to the audience participation part of the agenda. So the issue arose from sort of the historical evolution of international criminal law as melding inquisitorial and accusatorial systems. And I think that's very important to keep in mind because I think the genesis of what we might call a problem or issue or tension between victims' rights and protection of defendants' rights stems from that effort to blend these fairly different criminal justice traditions. So on the one hand, we have the adversarial tradition, which is built on the premise of a contest between the prosecution and defense leading to the truth, leading to justice. And victims are not parties typically to those proceedings. Because of that contest, it doesn't really leave room for victims in the traditional way that it has been practiced. The central idea is that the state represents the victims. The state represents all of society, including the victims in the proceedings, and the defense counsel represents the defendant. So victims are viewed as having a voice really in participating with the prosecution in structuring the case and then as witnesses, and then in their own right, really only at sentencing in explaining to the judge the harm that they suffered so that might be taken into consideration at sentencing. Okay, in contrast, of course, we have inquisitorial models where the process is significantly judge-led, including by judges such as Judge Yu, in his experience both in his national system and then at the Postal Specialist Chambers, as investigating magistrates who investigate the case, including both inculpatory and exculpatory evidence, put together a dossier, a file that is the file for the case available to all of the parties. And in this context, victims have had traditionally a very robust role, from being able to initiate the proceedings or invoke the system to initiate the proceedings, all the way through participating actively in providing evidence in every stage of the proceedings, up through and including the participating in closing arguments, something that in my national system would be really anathema to the process. And they can also be civil parties claiming reparations as sort of part of the same process, which again, in the system that I'm most familiar with, is very much a separate process, not at all linked to the criminal process. So international criminal courts have, over time, blended these systems, culminating in the efforts of the ICC to effectuate the blend. But we started with Nuremberg and Tokyo in a position that was much more adversarial and didn't as much seek to include the inquisitorial model. And then we had at the ICTY, ICTR, and mechanism, following on the tradition of the Nuremberg and Tokyo courts, I think a system that more replicated the system of two parties essentially contesting the truth. Although we have debates about internally about the extent to which our system melds the inquisitorial and accusatorial models. But I think one provision in the statute sort of reflects the fact that victims were not really central to the process in the way that they became at the ICC. And that is in this, an article in the statutes that says, proceedings are conducted with full respect for the rights of the accused, full respect, and due regard for the protection of victims and witnesses. So the aspect of protection of rights was really focused on defendants, and the due regard for the need to protect victims and witnesses was in some ways not as central, we could say, or at least it took, I shouldn't say that, it really was a separate kind of a thing, as opposed to also protecting the rights of victims to participate actively in the process. And of course, we don't have a scheme for reparations at our court either. Then there were some internationalized courts, such as the special panels for serious crimes in East Timor, and perhaps even more notably, the extraordinary chambers in the courts of Cambodia, that were rooted in, and because they were internationalized, they combined national systems with international participants and norms in a way that enabled them to call on the norms of the civil law system much more robustly. And so we had a kind of new model evolve from these internationalized courts that then was picked up on in Rome when the International Criminal Court Statute was negotiated. And the French delegation was particularly active in Rome in ensuring that the civil law system was very much incorporated in the model that was adopted. And so in the ICC, we really have an innovative blend of the traditions. And that has been lauded in many regards for the way in which it promotes the rights of victims, centers victims in the process of achieving justice. And I think most participants in the system agree that a primary purpose of the system is to provide justice for victims. I think it's a common mantra of many participants in the system that is what it's all about. And so the ICC, by blending these traditions, is able to center victims in this way. So judges at the ICC are engaged actively as fact finders in various ways, including the role, for example, of the pretrial chamber in authorizing pro primo investigations. Just one example of many of how the systems are really blended. And with regard to victim participation in particular, Article 68.3 has some very important language, which I'll read. where the personal interests of the victims are affected, the court shall permit their views and concerns to be presented and considered at stages of the proceedings determined to be appropriate by the court and in a manner which is not prejudicial to or inconsistent with the rights of the accused and a fair and impartial trial. So that article really puts very clearly the need to balance the rights of participation of the victims and the fair trial rights of the defendants. And I think, and then there are also in the rules of procedure and evidence, there are many victims' rights that are elaborated in great detail, and I won't go over all of the statutory or rules procedure provisions that allow for this, but they include making opening and closing statements, attending and participating in proceedings, filing written observations and submissions, accessing documents, questioning witnesses, etc. So as you can imagine, this leads to a potential for a tension between, or even a conflict between the rights of the accused and the participation rights of victims that the judges of the ICC have really been left to sort out in the way that they conduct proceedings. And so this is why, and this is where I will step back and not pretend to have deep knowledge of the ways that this has worked itself out at the court and hope that others will chime in. But I will give just a few examples. There's been some important jurisprudence that has come out of the appeals chamber, including holdings that limit victims' participation. For example, holding that proceedings, for the purposes of the right to participate in proceedings, doesn't include the investigative stage. And also that there shouldn't be an extremely broad understanding of victims' personal interests that had developed in some of the trial chambers before the appeals chamber ruled on it. That being said, the pretrial chambers and trial chambers that have started to work out the jurisprudence seeking the right balance here have sort of struck widely different, I think the practitioners might say, balances. And according to my friends, as we were speaking briefly about it this morning, it does depend, not surprisingly, to a significant degree on the judicial background of the judge, right? What they're used to in their national systems, how they interpret victims' rights to participation. So they've allowed varying levels of access to documents, varying levels of ability to participate in different kinds of hearings, including whether they're in camera or ex parte kinds of hearings, and the like. And then I should also mention the development of the common legal representative that enables the participation of victims through a common representative in court, which has in some circles been lauded as a very important development in enabling victims to participate meaningfully while also not prolonging the process or encumbering the process more than would be sort of manageable as a logistical matter. And in other circles has been lamented as sort of undermining the rights of victims to participate as meaningfully as possible in sort of representing their own suffering throughout the proceedings. So just one example of this tension that I mentioned before. Two other things, should I just finish these two other things I wanted to mention? The process as it has evolved at the ICC has followed or tracked or mirrored a similar evolution in human rights law more generally, a tendency in human rights bodies and at the United Nations to recognize robust rights for victims of participation. So the ICC victim participation regime was significantly modeled on the 1985 Declaration of Basic Principles of Justice for Victims of Crime and Abuse of Power, adopted by the United Nations General Assembly. And then later there was the 2005 resolution of the UN Commission on Human Rights that contains guidelines on this issue. The EU adopted a directive in 2012 on victims that recognizes robust rights of victim participation, of course, making allowances for differences in national systems. The European Court of Human Rights has found that victims that have become parties to a criminal proceeding have a right to a fair trial, which is different than in other systems. The Inter-American Court of Human Rights has found general principles of victims' rights to full access to proceedings, to criminal proceedings. And the African Court of Human and People's Rights, and please, those of you who are deeply embedded in this system, chime in here as well, has not yet focused as much, to my understanding, on developing victims' rights to participation in criminal proceedings. But the Charter does have a provision that every individual shall have a right to have his or her cause heard, which could be interpreted and developed in this vein, should those bodies choose to do so. So I'll end this part there by saying that there have been, I think, a lot of early criticisms of the ICC in the commentary as potentially violating defendants' rights to fair trial, to expeditious trial, and the like. And we can talk about that more in Q&A if folks are interested. But my view of the commentary sort of broadly is that it has evolved over the years to be much more open generally to finding a solution to this, to finding a way to enable victims to participate meaningfully in the process while not infringing on defendants' rights. So I'll end there.
Thank you very much, Judge de Guzman, for the informative presentation, and which raises, of course, very important issues of the parameters of victims' participation in proceedings. We will come back to that. Ms. Segueta, I will turn now to discuss some of the fair trial guarantees developed by the international tribunals. It is well known that the ad hoc tribunals were at the forefront of developing standards and procedural safeguards to ensure respect for fair trial rights in cases concerning allegations of atrocity crimes. And it is settled that the prosecution's disclosure obligations are at the crux of ensuring the accused's ability to adequately prepare their defense in such cases. So, Ms. Segueta, turning to you now, how did the rules on disclosure evolve at the ad hoc tribunals?
Thank you very much, Amelia. Good morning, everyone. First, to say that I am deeply honored to be part of this panel, and I will take advantage and thank President Gatti Santana for inviting me to participate. Now, the question of disclosure, the prosecution's obligation to disclose materials to the defense has always been at the heart of fair trial rights at the ad hoc tribunals. And this has drawn from Articles 19 and Article 20 of the statute that establishes these two tribunals. And they have evolved, but what is obvious is that right at the beginning, the rules that were governing procedures and evidence of these tribunals mandated the prosecution to disclose to the defense statements of witnesses who the prosecutor intends to call to testify at the tribunals. And that was a fair trial right based on the fact that the defense has to have adequate time to prepare for his defense. And how are they able to do that? When the defense has access to the statements of people who are going to testify in their defense, then they are able to see lines of cross-examination and things like that. So that is one way in which is giving them adequate time and adequacy to prepare for their defense. However, tied to the obligation to disclose statements of witnesses who are going to testify, the prosecution has always also had the obligation to disclose exculpatory material, but that has evolved over time. In the early days, it was just broad in scope that the prosecution has an obligation to disclose exculpatory material. It was only in 2004 that the rules were further developed, giving the prosecution a more defined scope and of how it should do this. And in 2004, the chambers set certain standards according to which the prosecution has to provide these exculpatory materials to the defense. It didn't anymore leave it open to the prosecution to decide how it was going to do it. They said specifically that the prosecution has to be able to do it in electronic form and also provide the defense with the necessary materials to be able to search those statements. But the question is, was this enough? It was found that it was not enough because following this amendment to the rule, the prosecution then developed an electronic disclosure suite in which they saved a number of witness statements in redacted form, in which they felt, as the prosecution, the defense should be able to go in there and search for exculpatory material. The trial chambers and appeals chamber found themselves again in a situation where it further has to develop and resolve this issue. And this was because the prosecution felt that for as long as they have saved materials in the electronic disclosure suite, the defense can go in there and identify what's exculpatory. But the appeals chamber said, no, that is not enough. You as the prosecution have the obligation to actually search and identify for the defense what is exculpatory and what is not. That disclosure suit is not, doesn't save you from that further obligation. And there were several reasons why that was important for the prosecution to actually do this additional step of actually searching and identifying. First, it was because of the number of statements that were in the volume. And secondly, the fact that they were in redacted form, which was necessary for protecting the identity of the protected witnesses. And thirdly, they were not particularized in accordance with individual cases. So if a defense counsel is defending person X and they go in there and they find tons of statements which are not very clear whether or not, or the extent to which they relate to their defendant, it wasn't easy. So that's why the appeals chamber went ahead and said, additional to you saving the materials in the disclosure suit, you have to actively search and identify for each and every of these defendants what is exculpatory and what is not in their case. Now, regarding the broader scope of disclosure, there is harmony between international standards and some national courts as far as concerns disclosure of inculpatory material. However, national courts are not yet at the stage where they have a positive obligation to disclose exculpatory materials to the defense. So as it is in different jurisdictions, for example, Kenya, Lesotho, South Africa, Nigeria, the prosecution has an obligation to disclose inculpatory material, but not yet an extended obligation to also disclose exculpatory material to accused persons. Now, the question now would be whether there is room for harmonization of these standards as far as concerns national jurisdictions being obliged to also disclose exculpatory materials. And I will argue that yes, there is room for this harmonization because constitutions of countries also include fair trial standards. And all these fair trial standards that are included in constitution of countries are drawn for the United Nations Universal Declaration for Human Rights. And if that is already, there's already that international standard that is binding all these national jurisdictions, and the fact that the fair trial rights in the constitutions of these national jurisdictions are drawing for the United Nations Universal Declaration, there is no reason why there shouldn't there be this internationalization of standards at national courts for them to be at the same par as international courts. And this, in fact, is what happened in the jurisdiction of Lesotho in 1997, when for the first time, the prosecution was given this obligation to disclose inculpatory material. Before 1997, the situation in Lesotho was that in criminal proceedings, the police docket, which contains all witness statements, was privileged, and that the accused persons were never entitled to seeing it. And you can imagine that always presented difficulties. There was always an element of surprise. The defense was never able to adequately prepare for their defense because they did not know what the witnesses were coming to say. And then in 1997, there was a case in which the defense brought out this issue of this is contrary to fair trial rights in the sense that we're unable to prepare for our defenses because we don't know what the witnesses of the prosecution are coming to say. And the judge in there said, the application before him is without precedent in the country. Accordingly, he took the liberty to seek guidance from other jurisdictions with similar constitutions to Lesotho. And it was his considered view that Lesotho law should fall in line with the international trend. And it was easy to do that because the Lesotho constitution contains the federal rights that are also available in the Universal Declaration for Human Rights. And it is for this reason that I am saying harmonization between international standards that now recognize the obligation to disclose exculpatory material is very easy to do for national jurisdictions as well. Thank you.
Thank you very much, Ms. Segwete. And you touched on a subject, the disclosure obligation of the prosecution, that is extremely important, of course, in the context of fair trial, and the prosecution is under great scrutiny to perform its obligations in this regard. And I'm sure there will be more questions, and we'll come back to that. But you also touched on the issue of harmonizing standards between domestic and international level. And in this regard, I would like to turn back to Judge Bosse now. If you, Judge Bosse, could please elaborate on the challenges that you personally see in harmonizing standards of justice. The microphone, Judge. You have to turn on.
Thank you, Madam Moderator. There are various challenges. While the courts have strived to establish harmony in the jurisprudence and not confuse stakeholders, challenges remain because international criminal law is a new field. There are many roads that remain untraveled, and with the enactment of the Rome Statute and the establishment of a permanent court in international criminal law, the fields that are yet to be harmonized remain many. But some of them are beyond the control of the judges. Others, the judges could do something about them. What the judges could do something about is their judgments. The statute allows the judges to, as much as possible, make their judgments by consensus, but where this is not possible, the majority judgment will be the operative judgment, but the minority judgment must also be included in the judgment. Now, at some point, they developed this practice of people saying, I'm also making a concurring judgment. Others are saying it's separate. We are allowed to make separate judgments and dissents. But there were many judgments that they were beginning to confuse the public. So we had to sit down. We have annual retreats where we sit down and synchronize what is working and what is not working. And I must also mention that we don't have elaborate procedure codes like the ad hoc tribunals had. Pre-trial chambers and trial chambers have to sit down and decide on the way forward on how they are going to conduct their proceedings. So depending on the orientation of the judges that are sitting in the case, some may be civil law inclined, others are common law inclined, others may be a mix. A predominant approach will emerge. So sometimes you find one chamber within the same, for example, a trial chamber. One trial chamber, let's call it X, taking a certain approach, and trial chamber Y taking a different approach. These are all roads leading to justice, as long as there are no major inconsistencies in what they decide. These are allowed. So also, there are some approaches that we have not yet synchronized. For example, on witness proofing, and I think one of my colleagues is going to talk about that. Judges don't simply agree whether we should have witness proofing or not. They don't agree on no case to answer. So those remain outstanding issues, which are a work in progress and which we are trying to iron out. Every year we meet and say, okay, now having tested this, we think it will work. let's put it in the practice manual. We have a practice manual, and once it is in the practice manual, chambers are obliged to pay deference to it. It's not binding, but it's a guide. We are also allowed to depart from our judgments if we think that we now think better of the issue. So, and we have good reason to do so. So that also might cause confusion, but is usually in the best interests of the court and justice and the parties. Victims are another problem for the judges, because we have different sets of victims. We may have different sets of victims in the same trial. We have victims of the crime, then we may have child soldiers who are also victims, and they might have different counsel. As always happens, they have different counsel, and sometimes they don't always want the same things. And remember, there are also the fair trial rights of the accused person. So this balancing act is not an easy one. These rights must be balanced, and the courts must come up with a final decision on the issue. Where pre-trial chambers or trial chambers have come to different approaches, and there is need to synchronize them, the appeal chamber will make the final announcement on the issue, and the other chambers now will be obliged to follow the judgment of the appeal chamber. One other issue that was touched on by the keynote speaker, which is coming up acutely in our proceedings, is artificial intelligence. Trials are changing. We have all these developments in technology where we can get real-time evidence, which formerly was not the case. With all the witnesses, many of them would have died, and the few survivors might have been intimidated and so on. Now we can get real-time evidence of crime scenes, massive graves, a mausoleum which was standing and is now in ruins, and these technological machines can establish the exact time the mausoleum was destroyed. We have user-generated evidence where people are on the ground and they take videos of certain scenes of crime, and then it becomes difficult to authenticate some of the things, because, as has been said, they can be manipulated, they can be disappeared, they can, So these are challenges that are coming up for us. For some of them, we're not very prepared for them because we're always lagging behind technology. We need a lot of training, and we are trying to find the best ways to cope with some of these developments. It's not easy. So we have to find a way of authenticating all these new types of evidence to make sure, because our duty is to establish the truth. As she has said, when the prosecutor is investigating, he must also unearth exculpatory evidence and has a duty to establish the truth for the records, because as the main speaker said, we have genocide deniers, revisionists, and so on. So the record of the conflict will show who did what, and we must be careful that the evidence that we accept is really authentic evidence, and this is not always easy, and we can only try our best. So the judges are conscious that they have to be consistent and they must harmonize their jurisprudence. We are under public scrutiny 24/7, whatever we do, whatever we say. So we have to be very careful. And we are critiqued a lot by academicians like my sister here, which is good. We like it because then they put us on the straight and the narrow. I think it helps us to be better judges. There are many more areas, but if time allows, I will. And of course, standardization of our jurisprudence. We can make mistakes like all human beings. We may have made a decision in a certain case, and now we think we were wrong then to make that decision. We can depart from it for good reasons and make another decision. I stop there for now. Thank you.
Thank you very much, Judge Bossa. Thank you for providing information on the working methods of the judges of the International Criminal Court, the challenges you face, and the need for consistency in the jurisprudence. And I will pick on several issues that you raised in your presentation and try to explore them further with the other two panelists. So, Judge de Guzman, perhaps just as a follow-up from what Judge Bossa mentioned about victims' participation being delineated differently by different chambers and different judges of the International Criminal Court, to what extent, in your view, the effectiveness of victims' participation in the proceedings before the ICC is contingent on the judge's interpretation of the Rome Statute? Clearly now we're beyond the question whether victims should participate. This is not being questioned anymore. But the effectiveness of their participation, to what extent is contingent on the judge's interpretation of the rules? And do you think that it needs to be legislated in greater details?
So questions of effectiveness are always very tricky. And I think the way that I tend to look at questions of effectiveness is through a lens of aligning practice with purpose. So I would say that the extent to which victims can participate certainly depends on the particular judge's interpretations of the statute. Then the question of how effective is that participation depends on what one thinks the ultimate purposes of the enterprise are. And from my perspective, prevention is the main purpose. And so for many years, I'll say, and perhaps controversially, that I was quite skeptical of the victim-centering approach, because it seems to me that the most effective way in which international criminal courts can contribute to prevention is not necessarily through individual or specific deterrence. And I certainly don't take a retributivist view of the theory of international criminal law, but is through an expressive kind of prevention, a positive general prevention, it's sometimes called. So that kind of expressive prevention really comes from primarily from the judgments and the way that the proceedings are conducted in compliance with human rights and those kinds of things. And the danger of centering victims in that vision may be that it gives rise to expectations that the process really can't meet, right? Because a court like the ICC can only adjudicate an infinitesimal fraction of the crimes that have been committed in the kinds of situations that it typically addresses. And so the possibility of really giving any meaningful satisfaction to victims is really a remote one for most of the time. That being said, I will caveat this by noting that I've been thinking more about the restorative justice role that these proceedings can play. And so I think that if you think of the purpose, one of the purposes as contributing to restorative justice, then a more robust role for victims is justified, it's easier to justify in that frame. And so ultimately, I think that the process, there's just going to be more trial and error to figure out the right balance. And it may be ultimately that there's a need for flexibility. So to have more robust participation in some situations than others, which of course goes against harmonization and may be controversial, but having, for example, if the ICC takes up a situation in which the national courts are very much engaged, and there's one in particular that comes to mind that's before the ICC now, where the national courts are doing many, many investigations and prosecutions and are very capable of doing that. So the ICC's role may be limited to a very symbolic norm expression at the global level, whereas the restorative justice is taking place largely at the national. That may be different than a situation in which there's very little prospect in the near future of meaningful justice for victims in the state involved, and the state most affected. And the ICC is really the only game in town in terms of providing victims with some kind of restorative justice, in which case it may make sense to have a much more robust, again, this would be difficult to reconcile with the idea of harmonization, but it may be, in terms of effectiveness, it may be the best approach.
Thank you very much. And if I may follow up with one more question. Because often when we speak about victims' participation in the proceedings, defense may express strong views that victims should not become second prosecutors in the proceedings. And just to touch on this criticism that at an international level, some state that courts have sought to expand or at least broadly interpret the rights of victims while narrowly interpreting the rights of the accused. Is, in your view, such criticism justified?
That states have done that?
Courts at international level have sought to broadly interpret the right of victims to participate in proceedings, afford them more possibilities, and narrowly interpret the rights of the accused to a fair trial.
So I think there's a real danger of that. And I wrote a bit about this in the book that I did on gravity, the concept of gravity, because I think that the fact that these courts adjudicate atrocity crimes, that word atrocity, right, which evokes this idea of the worst possible crimes that can be committed, can lead in some situations to decisions that view the evidence as so overwhelming, for example, that something terrible happened, and it can lead, and Nancy Combs wrote a very interesting book about evidentiary standards and did an empirical review of evidentiary standards that found that there was some lack of evidence in some cases, of course, very controversial findings. But I think that there's a danger in the context of atrocity crimes where there's a real expectation that the crimes have happened and that people in positions of leadership who are typically before the courts were involved in the crimes and so on, to curtail or to limit defense. It's a danger. Has it happened? I mean, you'd have to talk about very specific individual cases to see, where that has played out. But I do agree also with the second part of your statement, particularly at the ICC, that there's been a move toward expansive participation of victims, and certainly in line with the court's mandate and statute that has happened.
Thank you very much. Let's move now to another issue, actually two issues that were raised by Judge Boss in her presentation, the issue about electronic evidence, admission of electronic evidence, and witness proofing. So on the issue of electronic evidence, of course, with the development of technology, we also observe the frequent use of electronic evidence, whether it's intercepted communications, social media posts, or other type of electronic evidence. And Ms. Seguede, what in your view are the challenges and the risks to fair trial rights that such evidence may pose?
Thank you, Amelia. And I will address this issue particularly in reference to intercepted communications that are being offered as evidence in criminal trials. The risk that such evidence poses is infringement of the right of the accused person to due process and or equal protection of the law, because it centers around the manner in which the intercepted communications are maintained before they can be submitted in evidence into criminal proceedings. So it is true that lately, when we see the trend of crimes, the trend of atrocity crimes, the way in which they are committed, it is becoming apparent that this kind of evidence is going to be very, very crucial in criminal proceedings. Sometimes, or in most cases, you find that these crimes are being planned at very high level government or other high level authorities. And the best way or the easiest way that we have seen lately of obtaining linkage evidence is through intercepted telephone communications, call data records, maybe emails or things like that. But now the risk of the right to due process is in the manner in which then authorities of a state in which these crimes are being committed seek to get that evidence before it can be submitted into court. And the best way of making this possible, when we look at the trend in which our way of presenting this evidence is going, is to have national authorities make it possible for lawful interceptions to take place. Because before that such evidence can be admitted, first the prosecution has to jump the hurdle of showing that such evidence was lawfully obtained. And that protects accused persons from unfairly being spied, for lack of a better word, by authorities of states. So the best way to protect that fair trial right of due process would be to set up laws that protect, that make it possible for interceptions to be done in a proper way. And then that will make it possible for such intercepts or emails or anything electronic to be admissible. And for that to be lawful, it must be conducted in accordance with national law, following due process, after receiving proper authorization from competent authorities of a state. An example that I can give is maybe in a recent case at the mechanism where we were prosecuting persons for interfering with the administration of justice. It would not have been easy to obtain evidence that would make convictions possible if we were not able to present solid and admissible and relevant evidence of obtained through intercepted communications. And if you are doing investigations in a state or in a country that does not provide for that lawfulness of making it possible for you to obtain such evidence, then you're not going to be able to have convictions in such trials, and also in atrocity crimes that are being planned at high level, where the only way or the easiest way in which you can get linkage evidence is through intercepted telecommunications, CDRs, emails, or things like that.
Thank you. And just if we can move to the subject of witness proofing, which is a very touchy subject, maybe if you can first explain for those in the audience who may not be aware of that concept, what witness proofing is. Obviously, there are differences in different tribunals. And then if you can elaborate on what are the risks, again, that witness proofing may pose to the fair trial rights of the accused.
So witness proofing emanates from a common law practice in which a prosecutor is allowed to proof or to prepare a witness before they come into court. And in reality, how it happens, you sit with the witness, you talk to the witness, you confront, for lack of a better word, the witness with this previous statement to see whether the evidence is still the same before basically preparing the witness to come to court. So it has been referred to as witness proofing. The risk that it poses to protection of fair trial rights for accused persons is that it presents an opportunity for the prosecution to develop its case as it goes. And if the prosecution is in a position where it's developing the case as it goes, it again presents that thing of an element of surprise to the accused person, because the accused person has a statement that was recorded in 1996 in which the witness is saying this. Then later in 2005, the witness is coming to testify, and then in a proofing session, something new comes up. And then it's always viewed as the defense as, oh, the prosecution's case is developing as it is going. Hence, there had been challenges at VICTR following a decision by the pre-trial chamber at the ICC that witness protection should not be allowed. And the defense made a valid case about the fact that, over the fact that it presents an opportunity for the prosecution to develop its case, and then the defense is obviously denied the opportunity to adequately prepare for its defense, because of course you didn't know that what this person was going to say. However, in as much as this practice has been allowed at the ad hoc tribunals, it is not because the judges did not see this possible risk of a case developing as the prosecution goes. And they sought to mitigate that risk by placing an obligation on the prosecution to disclose what we used to call will-say statements, so that during a proofing session, should a witness say something different or a little bit developed from what they had said in their statement that had already been disclosed to the defense, we're able to give the defense an additional will-say statement to say, additional to what there has been said in the statement you have, this is what the witness is going to say. Further to that, in the later years, the prosecution is also obliged to provide proofing notes to defense counsel at least 24 hours or 48 hours before testimony. That is another layer of mitigation of this risk of denying the defense the possibility of adequately preparing for their defense, because you are now coming with new things that did not exist in the previous statement that you disclosed to the defense.
Thank you very much, Ms. Seguete. I now turn to the audience. We have laid in front of you a plethora of issues that go to fair trial rights and harmonization of standards of justice. So now I invite you to ask your questions. If you have any questions for our panelists, we must have a microphone that is available. So if you can raise your hand and we'll bring the microphone to you. Judge Sekule, here on the second row.
Panelists, thank you for your very enlightening presentation you have just made on very crucial issues regarding the rights, human rights in criminal proceedings, fair trial rights, and harmonizing of standards of justice. I'll deal with trial rights very briefly. Discussed by the panelists, in particular by Ms. Thambile, in the ICTL rules, there were very many provisions dealing with fair trial rights of an accused person. She has talked about them, and the panelists, other panelists have talked about them. I cannot recall all the rules that were there, but they were there and they were significantly followed. I'll give you an experience whereby some of them, of the trial rights, were not followed or violated. On appeal, we had situations where on appeal, even if a conviction was substantially upheld, but there were serious trial right violations, it had very much effect on the sentence. For example, we have had cases of an accused or some of the convicted persons sentenced to life imprisonment, quite a number of them actually, but on appeal, where the appeal chamber found that trial rights were violated, the sentence was reduced from life to a term of years. So that's an indication this matter was serious during the life of the ICTR, and indeed even during the present life of the mechanism. Various levels where these things were raised, checked, and dealt with. So I wanted just to give that example that these issues were almost seriously looked into whenever they arose at that time. They are very important safeguards, and I'm sure the process how to deal with them will ever continue with the new elements that are being talked about digitally and what have you. I like the short explanation Ms. Thambile has given about how you go about certain intercepted communications that you want to put into evidence. Perhaps it's a very, very, very useful, but very difficult technology, but I think one people to use as we go along in the future. Thank you very much. These are remarks I wanted to make.
Thank you very much, Judge, for your Judge Sekule, for your observations. Judge de Guzman would like to add.
Just wanted to, since we don't have defense counsel represented on the panel, I just thought it would be nice to turn to some defense counsel that we have here in the room who might be able to shed some light on Chris, Kate, in this third row there, would love to shed some light on the perspective of defense counsel and how well the rights are being balanced.
Ms. Gibson, I see you hold the microphone now. Please, you have the floor.
Yes, I'll always do what I'm instructed to do by a judge. So thank you for this really high level and interesting panel. Thank you for sharing your thoughts and experiences. And as indicated by Judge de Guzman, maybe I'll just pick up briefly on this topic of the harmonisation of victims' representation across the different trials at the ICC, which I think is a really important one. And I think both Judge Guzman and Judge Bossa were right to talk about the evolution of the participation of victims at the ICC, because we know that the rules of procedure and evidence were drafted in a way so they weren't overly prescriptive. And so a lot of discretion was left to the judges as to how to interpret a lot of these procedural issues. And in each trial, you have an order that comes just before the trial starts, this order on the conduct of proceedings. And it's a really interesting exercise to sort of print out and review the different conduct orders and see the very different procedures that have been put in place by the different trial chambers. And in the case that I was involved in at the ICC, in the Bemba case, we had a civil law-oriented presiding judge who was very interested in interpreting victims' participation in a broad way. So we had a very interventionist LRVs in our courtroom who were able to question and in fact cross-examine defence witnesses and experts. But go down the hall to the Lubanga proceedings, which was presided by a British criminal law judge, and he took a much narrower approach to this idea of the procedure of victims' representation. And in fact, victims were only allowed to intervene with witnesses when they could demonstrate through pre-approved questions that they wanted to question them on their views and concerns specifically. So two very different trials happening down the corridor from each other. And I'm very grateful to Judge Bossa for bringing up the Chamber's practice manual, because I think that's gone a really long way in working towards harmonising the procedures that we see across the different trials at the ICC. And now we have a much more standardised approach to victims' participation. And it's important because I agree with Judge Bossa that all roads lead towards justice. But one of the components of a fair trial is certainty for the accused and the defence, sort of legal certainty and procedural certainty, so we can give advice to our clients on what the trial is going to look like, and we can properly take instructions from them on how we should act in that procedural framework. So I fully agree that this evolution has occurred and is continuing to occur.
Thank you very much for these observations. Judge Bossa would like to make a comment?
2 comments. One is on participation of victims. With the reach which we had last year concerned at what stage of the proceedings should the victims be allowed to participate. You remember we have preliminary examinations, then we have investigations, then we have all the procedures that follow. Some judges would like to see victims represented as soon as their interests are exhibited in the proceedings. Others say no, at preliminary examination, the prosecutor has not even fashioned his case in any meaningful way. He's just feeling his way around. He might even decide not to investigate, and so on. So at that stage of the proceedings, the victims should not be represented. And the judges have decided that that is going to be the case in the last retreat we had. Now, regarding intercept evidence, we have upheld a conviction last year of Ongwen on intercept evidence. And what the trial chamber required of the prosecutor was to authenticate that the people who made the intercepts, who were intelligence agencies, properly recorded them, they were verified, and they came and confirmed that yes, we did these intercepts on these dates, and this is what we had, and we translated it in these books, and this is what they mean, because they were in Luo. So none of us would, understood the language. So after examining all these procedures, the trial chamber convicted Ongwen, and that conviction was upheld. So intercept evidence, if the source of the intercept evidence is credible and it is authenticated, it will stand.
Thank you very much, Judge Bossa. I can see more hands being raised in the audience. I just want to take this opportunity at the very last moment to ask our panelists a question that is very relevant, I think. And as you're sure aware, 8th of March is coming very soon, is the International Women's Day. And this year, the theme of International Women's Day is inspiring inclusion. So since we have three very accomplished women here on the podium today, I would like to ask each of you if you could provide a very, very short answer, how, in your view, what we can do and how we can inspire inclusion of girls and women. Judge Boss.
Thank you. My first reaction is mentoring, because personally, to reach where I have reached, I was mentored by women judges and other professionals who were not women, who encouraged me to take the leaps, even when I thought I didn't really meet the standards that were required. So mentoring is a very big part which we have to play to encourage other women, professionals and non-professionals, to take the leap of faith and determine that they want to go somewhere and be bold to pursue what takes them there. The other one, of course, is to reach out to the unfortunate ones, because we are privileged to be lawyers and to have the jobs we have, and so we have to find a way of giving back to society, and especially uplifting those who are less fortunate than us. Personally, I do that a lot through our local associations in Uganda. We have women lawyers, we give legal aid, we have the Law Society, we have the East African Law Society. I think it's a way of giving back. And even in our localities, people approach you for this and that, advice here and there, and it's a way of giving back to society. So that's what I would recommend. But of course, everybody has their own ways. Thank you.
Thank you very much for the inspiring words, Judge. Judge de Guzman.
Thanks, Amelia. I would echo Judge Bosa's words and also those of our keynote speaker from the courtroom to the classroom. I think in addition to mentoring, focusing on education and ensuring equal opportunities to education for women and girls is crucial. We need to have women and girls who have the same level of education as everybody else in society, who can then become the leaders, become those who set the policies. And I think ultimately that will lead to a more peaceful and just world.
Thank you so much, Judge de Guzman. From the courtroom to the classroom. Mr. Goethe?
Thank you, Amelia. Agreeing with both Judge Bosa and Judge de Guzman, I would like to take it a step further and look at inclusion also together with our diversity, and to encourage young women and girls to be bold enough to also diversify. As we mentor, as we give back, also encourage this diversification for upcoming young girls, young women, not to only focus on one aspect of career, but to diversify as much as possible. There's a lot in the world that young girls and women can do. So diversification also, I see as another aspect of inclusion, because when girls diversify into a world that was previously known or commonly known to be just a men's world, then they are making themselves getting included into that men's world. Thank you.
Thank you very much. And with this, I suggest that we close our panel discussion. I invite the audience to give a big round of applause for our panelists.